Evening. Thank you so much for joining us here at 10. Today, a hearing took place in the lawsuit regarding the fatal crash that killed two SFA student athletes.
Graylin Spring and Micah McAfoos were driving in Corrigan on January 20th when they hit an 18-wheeler. According to DPS, the 18-wheeler had failed to yield to oncoming traffic. Both of the students later died of their injuries. KLTV's Avery Niles brings us the latest in the legal battle.
Both parties met again today in an Angelina County courtroom to discuss recent motions made in the lawsuit. The defense, representing the truck driver Antonio Sandoval Jr. and Hughes Trucking Company, filed a motion to bifurcate, which means separate the two trials. Judge Bob Inselman first asked the Spring family attorney, Nick Wooten, his thoughts on the motion. He says the judge could choose to wait on this motion.
You know, this bifurcation issue deals only with how the case is tried. It doesn't deal with anything with discovery or anything else. In theory, you could bifurcate it the day of the trial or a week before the trial or at a pretrial. Personally, I think we're sort of stuck with this rule the Texas legislature created, so we don't really have an argument in opposition.
Tim Newsom, the lawyer for the McAfoos family, was then asked his opinions. He says they entered the lawsuit after the Springs had already filed, making them the interveners in the suit. He says they were never named in this motion filed by the defense, and the statute says the motion has to be filed within 30 days of them entering. Newsom says the time has now passed for the defense to add them to the motion.
They didn't mention interveners in their pleading. They never asked for relief from the interveners in their motion. The only place that technically it asked for relief related to the interveners is broadly says this entire case would be bifurcated.
Newsom's argument is that without them being named directly, if the Spring family were able to reach an agreement with the defense, it excludes them from it completely. Jared Bloom, one of the defense's attorneys, says the statute says the motion for the plaintiffs filed has to be done within 120 days. He says the McAfooses are listed under the plaintiff's side and it was filed in the correct time frame.
That's just clarifying for the court that a intervener, a cross plaintiff, a counter plaintiff, a decedent's estate are considered a claimant. But it doesn't have anything, that's just the definition. That has nothing to do with the procedure for triggering the bifurcation. The triggering event for bifurcation is filing a motion in the stipulation within the 120th day after the original answer was filed, which is exactly what we did.
Avery Niles, KLTV 7 News.
The judge did not make a ruling today on this motion. A date for the next hearing hasn't been scheduled at this time.